welcome you to our special session. You've got the room all to yourself and our full attention this morning. On my right is Judge Palmer, on my left, Judge Lawson, and I'm Judge Sharp. 20 minutes per side. If you want to save time for rebuttal, appellant, you may. And there's a clock on the podium, which I think I can run, but if I can't, I'll just have to use my wristwatch. So we'll begin. You don't.
Morning, may it please the court. I'm Rick Hupfer from West Palm Beach, representing the appellant, the law firm of James T. Butler. I received a call on my cell phone from my client who was on his way over here and stuck in traffic in Orlando, so I told him I would say that to the court, so I just don't want you to think that he wasn't concerned enough to be here. He probably will be walking in just as we're finishing.
You're very brave to have your client come, I think.
If I could, I'd like to reserve 3 minutes of rebuttal time.
Right.
We're appealing a summary final judgment in this case, finding that Mr. Butler's law firm should forfeit all of their attorney's fees from Richard Farrow's, that's one of his clients' settlement with certain of the defendants, on grounds that the law firm had a conflict of interest in this case at all pertinent times. That was the language that was used by the trial court, at all pertinent times. The issue that we've raised on appeal, which I think is a purely legal issue, is whether a conflict of interest arose as a matter of law at the time that the two clients, the husband and wife in the personal injury case, began divorce proceedings back in 1999 so as to require their PI attorney to either obtain a waiver of conflict at that time or else forfeit his fee for all the services that he provided for the next 5 years after that, which culminated in some very large settlements in this case, totaling over $11 million. There were several settlements that were entered into leading up to the last settlement, which was actually involved here along the way, and those settlements went fine. They went like clockwork. No party disagreed either with the amount that was offered or with the allocation.
Now, when were those? Those are early?
They were early on, yes. They went from 1999 up until around 2002. There were 4 of those settlements. There was never any...
Relatively small amounts.
They were comparatively small, yes, in comparison.
Did he get his fee out of those small settlements? Did he get a fee for those small settlements?
Actually, he waived his fee.
He waived it.
He waived his fee entirely on the small settlements because the money was really needed by the clients at that point. So,
and there were then 2 large settlements, correct?
There were 2 large settlements, the 5th and the 6th.
The first settlement, the first large settlement, did that occur before or after the knowledge about divorce proceedings?
After. Several years after.
Do I understand that there is not a dispute about the fee on that before?
There is not, and this appeal does not involve the fee on that settlement at all. That settlement was for $5.7 million. It was Richard Farrow. That settlement was the allocation of that settlement was dictated by that defendant, Gilbert Southern, offered the settlement and offered how they wanted it dictated, how they wanted it allocated. Richard Farrow obtained 50% of the settlement, and the other 50% was divided among the remaining family members. Richard Farrow did testify later on that he only agreed to the 50% because he was promised at that time that he would get most of any future settlements. Our position,
which he apparently did, correct? He did get most of the future.
On the 6th settlement, he got 72%.
Is it your position that no conflict ever arose, and if not, when do you concede that a conflict did arise?
Well, I think certainly when Richard Farrow filed his objection to the allocation of the last settlement, I think at that point a conflict certainly arose, and my client withdrew within a couple of days after that. I think that arguably a conflict also, I'm stuck with Richard Farrow's testimony. I recognize that. Richard Farrow testified that on the morning the trial was about to begin, when that final settlement was offered, and everybody had a conference about it, that his wife, the reason why he agreed to 72% was because his wife threatened that she wouldn't testify at the trial if he didn't accept that allocation, and he felt pressured to do that. I think that possibly that creates, when a lawyer has multiple clients and one client is threatening the other client not to testify at trial unless a certain allocation is accepted, I think arguably that does create a conflict. But it's our position that that's the first time that an actual conflict occurred. And by then, the $5.4 million settlement offer was already on the table. That's why they were all gathered together, was to discuss whether to take it or not. And the contingency on which Mr. Butler was retained had occurred, and the money had already been offered. That was the offer that was ultimately accepted by the clients. I think that is when, the first time in this entire case, that an actual conflict occurred for Mr. Butler.
And what's the effect of the creation of the actual conflict in your mind with regard to fees?
With regard to fees, and I agree with the case law cited by my opponent, that at the time, once an actual conflict arises, if the attorney does not obtain a waiver of the conflict, then the attorney is only entitled to quantum merit up to that point, and is not entitled to fees after that point.
Based on when the fees were earned as opposed to when the fee was paid?
Well, it's based upon what at this point, of course, I think quantum merit would probably be based upon the amount of time that went into the entire litigation, bringing it all up. If quantum merit is to be applied in this case on the morning that the case was going to go to trial, then I think the attorney is entitled to quantum merit for 5 years worth of work and for
And in a contingency fee case, is quantum merit calculated on the time in the case or some proportion of the contingency fee based on how much work's been done versus how much work was done in the whole case?
I think it's multifactorial, and I think it's based. I think time is a very big factor. I think the results obtained is a very big factor. I don't think I've seen a case that say that it's based on a percentage of what the contingency would have been. I can be wrong. I don't think I've actually seen a case that says that.
And let me ask you this. Was there any claim by the husband that the amount that was accepted in settlement either was unreasonable or that he wouldn't have accepted that amount but for the conflict?
Your Honor, there was never a claim.
So the only effect of the conflict, from your understanding, is, yes, everybody agrees this was a reasonable settlement. How do you divvy it up between the parties?
The allocation was the only issue that created a conflict. And Mr. Farrow wanted 72%. Now, there's also no dispute that at that conference on the morning of trial, everybody verbally agreed to the 72%. In fact, and there's an indication in the record that they even initialed something, although whatever they initialed, I didn't see in the record. But there was no disagreement that everybody did, verbally at least, agree to that, and that the money was paid, the $5.5 million was paid into Mr. Butler's trust account, and it was later that Mr. Farrow refused to sign any settlement documents and claimed that he was pressured into verbally agreeing to the 72% because of his wife's threat.
Any dispute on the last settlement that the settlement was just a lump sum offer from the defendant? The allocation was done by the plaintiffs and their counsel?
I think, well, the last settlement, it was. It was, in the last settlement, I don't believe that, the last settlement was with Walker, Ritchie, and White Construction Company. I don't think that they dictated the allocation.
Typically they wouldn't, right? I mean,
typically they wouldn't.
In most cases, the defendant could care less how it's divvied up as long as they get out of the lawsuit.
That's correct.
Right. On the first large settlement,
yes.
Was there, do I understand there was a factual dispute about who divvied it up?
Oh,
I thought I read something in the husband's deposition that he basically said, the lawyers lied to me because they told me the defendant was divvying it up, and I determined that it was actually not being divvied up by the defendant, and it was the plaintiff's lawyer who decided how to divvy it up.
I may have missed that when I read it because I don't recall what you're saying. But my understanding was that it was that defendant who made the suggestion how they wanted it to be allocated, and it was allocated that way. But in order for the husband to agree to, Richard Farrow to agree to that, he was promised that they would take care of him for any future settlements, and he would get most all of any future settlements.
Tell me, how does it work in a typical personal injury case at the beginning when you have claims for a husband and a wife with regard to potential conflicts? Is there something about the fact that they ultimately are going through a divorce that would create a potential conflict, or would there be the same, at least, potential for conflict from day one? Because presumably you've got a husband and a wife, they have different claims. If there was a lump sum offer, there'd have to be some way to divvy it up, and even though they're husband and wife, there could be that potential. Or
I think there's always, whenever a lawyer represents multiple clients, whether they're family members or not family members, there's always a potential that the clients may not see eye to eye on every issue that comes up.
And does the plaintiff's lawyer, therefore, at the beginning of the representation, have some obligation to tell the clients there is a potential for conflict if we get to the point where there's a lump sum settlement and there's a dispute of how to divvy it up, and I'm telling you now about that, or is that something that you don't have to deal with until you get the lump sum settlement and you discover there's some fight about how to divvy it?
Okay, I believe that the law and our position in this appeal, based on the Wiggins case, is that just because that is always a potential when you have multiple clients, I don't think that it requires a waiver of conflict every single time a lawyer has more than one client in some kind of a disagreement.
Isn't the Wiggins case somewhat distinguishable on that point, in that in Wiggins the court recognized that the statute required a sole, in other words, only the personal representative can represent the estate, so, and all claimants. So there's no potential for additional representation since they have to speak through one voice. Isn't that different in
There is
wrongful death case?
Factually, there is a distinction between the Wiggins case and this case, but looking at the discussion of the court goes on and it cites some of the rules in the Code of Professional Conduct, and there's a discussion in there, and I think that we quote from it verbatim in my initial brief when I discussed the Wiggins case, where they talk about a lawyer representing multiple family members who have all been injured in one personal injury case. I think the Wiggins case you're right, was a wrongful death case, and we have one wrongful death case involved here too. But what the Supreme Court seems to say, and I don't think it's dicta, I think it's part of their reasoning that went into the case, even though, yes, on its facts it is somewhat distinguishable, is that it's not a conflict of interest for one lawyer to represent multiple family members unless the lawyer knows that they have adverse interests to each other. For example, if there's going to be cross-claims filed between them, obviously one lawyer can't represent them all without obtaining, even actually he could if he or she could if they obtained the waiver, but that does create a conflict. There was never anything like that in our case. I thought as far as the divorce proceedings being filed, I don't think that it's any different than a lawyer who was representing a partnership, a business partnership, and let's say they're suing somebody for breach of contract, and then a couple of years into the lawsuit, one of the partners files an action to dissolve the partnership. But they still have a commonality of interest. They still both want to win the breach of contract action. I don't think the fact that fact would constitute a conflict of interest for the lawyer unless they actually get into bickering about the allocation between them. The lawyer can't choose sides between his own client. Then at that point, there's an actual conflict of interest. I don't see how that differs really from a situation where it's a marital situation and a divorce. Incidentally, one thing I think is important here too is that although the divorce proceeding was initiated way back in 1999, it was abated for all these years that this personal injury litigation was going on because they didn't want to impact the personal injury litigation with the divorce proceeding. Again, everybody was presenting a united front. We went through 4 settlements. Yes, they were smaller settlements, but everybody was seemingly on the same page. And so our position is that there's no conflict, actual conflict that occurred in this case up until the time where Richard Farrow testified that his wife threatened him not to testify if he didn't accept the 72% allocation. And at that point, as I say, I think his contingency has already occurred. He's obtained the settlement offer.
On the first larger settlement, seemingly they were on the same page as well, correct?
Well, Richard Farrow testified that the impression that I got from his testimony is that he wasn't really even happy with the 50% that was dictated by that defendant, but that he agreed to it in return for the promise that he would get most of any future settlements. So, and I don't think that...
Was the evidence from Mr. Farrow that he expressed that concern at the time of that settlement, or did all this just come up at the time of the second settlement?
No, I think his testimony is that he expressed that concern at the time of that settlement, and that's why he was told most of any future settlement you'll receive. And again, the fact that clients have an agreement between themselves how to allocate future settlements in order to agree on a present allocation of the present settlement, I don't think that creates a conflict for the lawyer. It's when the clients can't agree on an allocation that the attorney then has a conflict situation come up.
Can the lawyer participate in that allocation discussion or agreement between clients?
The lawyer ought not. I think the lawyer, if the clients cannot work it out amongst, no, but I don't think the lawyer can take
So
sides.
typically, when there's a lump sum settlement made, he's got to present it to his clients and say, this is the lump sum. It's somehow got to be allocated between the two of you. I can't get in the middle of that. See if you all can agree on how to allocate it, and otherwise maybe you got to get new counsel to deal with just the allocation issue.
It's a very touchy subject when that happens. I think that the lawyer can make a recommendation, which is strictly a suggestion. And if the clients can't agree, they don't necessarily have to agree with that suggestion. They explain why he would make a certain suggestion. Maybe there would be tax reasons why it should be allocated a certain way, and he's their lawyer and he should explain this. But I don't.
Or he could evaluate the relative claims in the sense that you've got these kind of damages, you've got these kind of damages. Given the disproportionate amount of damages, a reasonable allocation would be 70-30,
Right.
but I represent both of you, so I can't do anything more than suggest.
I think that's perfectly okay for a personal injury lawyer to do that. The position of my opponent is that if that's a conflict situation, and you've got to obtain a waiver of conflict before you can do something like that. I don't believe there's any cases that say that before the trial judge held it in this case. The one thing I also want to mention as well, which I think makes the result in this case erroneous, is that Mr. Farrow admitted in his testimony, at first he denied that Attorney Butler ever discussed anything about a conflict, but then later in his testimony, he does admit that at least at some point in the litigation, and he couldn't really say exactly when in the litigation, that there was a discussion between the three of them, Mr. and Mrs. Farrow and Attorney Butler, about a possible conflict, and that he wanted Attorney Butler to continue representing him. And he also admits later on that he discouraged Mrs. Farrow from retaining her own independent attorney from representing her. But what they're saying now in their appellate brief is that he was told by Attorney Butler at that time that Attorney Butler would only represent his interests, even though he was ostensibly representing everybody, and that he would represent Mr. Farrow's interests over his wife and his children's interests. I don't think if you read his testimony, which is at page 250 to 251 of Volume 4 of the record, incidentally, I'm using the court reporter's pagination for that. I don't think the spin that they're putting on that testimony now is really not.
Counsel, I'm warning you, you're getting to the time you wanted to reserve.
Oh, okay, and I am. So in order to not to lose that time, if there's no other questions, I'll save that time for
Thank you.
Thank you.
Morning, Your Honors. Roy Watson representing the appellee. Mr. Farrow. My friend Mr. Kupfer there keeps trying to turn this into a question of law, and the issue is not, as he argued, whether as a matter of law a conflict of interest arose at a certain time, but whether as a matter of fact. This was a decision made by a judge after hearing evidence from witnesses.
What was your position below as to when a conflict arose?
Below as to when?
What was your position below? What did you argue to the trial court as to when the conflict?
I believe it arose back in 1999 when Mr. Butler approached Linda Farrow and discussed with her the potential for a conflict.
How long had the case been going on as of then?
I'd have to refer to the
The
record.
case had been going on for some period of time prior to 99, correct?
Absolutely.
Okay. Was opposing counsel entitled to some fee out of this settlement that is the subject of the dispute to the extent of work done that led to that settlement prior to 1999?
I don't think so.
Why not?
I don't think that's the law. I think that once there's a conflict of interest, you're not entitled to recover a fee under a contract or under quantum merit.
But what about the work you did before the conflict arose?
Well, that work went into the prior settlement with Gilbert Southern, which he did take a fee out of his mind.
You agree he's entitled to a reasonable fee up till the time the conflict arose?
Yes.
What was the evidence that none of the time expended before 1999 inured to the benefit of the settlement that was reached that's the subject of this dispute?
I don't think that the evidence was taken on that point. I don't think, because the judge found the existence of a conflict, I believe that...
Yeah, the judge said at all relevant times, so we're trying to figure out what these relevant times were.
Well, my opinion, and maybe I'm shortchanging my client here, maybe but I think it was 1999 when even the initial brief itself on page 2 and 3 says that there was evidence that, quote, Butler spoke to Richard and Linda Farrow about continuing to represent them both in the personal interaction while their divorce litigation was pending. So he recognized himself back when that divorce was filed that there was this potential, and there's evidence from the other witnesses.
Well, are you now saying that an attorney doesn't get a fee starting at the point where there's a potential conflict of interest?
No,
Okay.
no, I think that there was an actual conflict then, and that...
What was the actual conflict?
Well, that Richard and Linda were at odds, and they wanted
At
to...
odds about what?
At odds about who was going to get what share of the settlement, and Linda was not going to testify and cooperate unless essentially she...
That was on the day of the trial, right preceding the last settlement, correct?
No, preceding the next to the last settlement, the Gilbert Southern settlement, Richard Farrow testified that he was, quote, pressured hard by Butler to take the 50%, or Linda would not testify, and that's on page 476 of volume 4 of the record. That's before the second settlement. Unfortunately, we've not raised any issue with regard to that second settlement. Maybe you shouldn't have, or that, the next to the last settlement, the first big one, maybe he shouldn't have gotten a fee from that, but that's not an issue. That's not before the court here. But
Was there any dispute between the parties as to the reasonableness of the offer or the acceptance of the offer from the defendant, or was the only dispute who gets what part?
Well, I don't think there was any. I don't quite understand, because of course the plaintiffs wanted more money. Of course the injuries are deserving of more money. I believe in this case Mr. Farrow's in a permanent quadriplegic.
But Mr. Farrow's not saying that because of the conflict I accepted a lesser amount from the defendant than I should have, correct?
That's not it.
His only argument is, given the amount of the settlement, how much of it do I get? Correct?
I think that's a fair characterization.
Okay. That conflict as to how much of the settlement do I get didn't arise until the settlement was on the table, did it?
I think it did, because I think it arose back before the Gilbert Southern settlement, when the testimony is, and the judge could well find, that Mr. Farrow only agreed to 50% of that settlement with the understanding he would get all or virtually all of the next settlement. And so he really took less than he had expected to take from the Gilbert Southern settlement. So that's
Well, I believe the testimony was all or most of the next settlement, not all or virtually all, wasn't
most
it?
or pretty much all, I think, is the quote here on page 476.
All right.
Like I say, this is just a sheer factual question of both the existence of the actual conflict, which I think the court could well find, as I said, came up before that Gilbert Southern.
Well, is it your position then that the conflict arose at the time of the distribution of the proceeds on the Gilbert Sullivan settlement?
Was that when the actual contract happened?
I think it's there at the latest time, yes.
The latest.
Yeah.
Well, what actual conflict arose at any time earlier than that?
At the time of the agreeing to the apportionment of that settlement.
Okay, that's the earliest time. You said it was the latest time. Is that the time
I
then?
misunderstood. I thought you said the distribution of the settlement.
Okay, when the allocation of the Gilbert whoever came up is when you say the actual conflict arose. Is that correct?
Yes, sir.
As of that point in time, had the plaintiff's counsel earned some portion of their contingency fee because of whatever work they'd done to get to that point in time?
Not on the later settlement. Not on the later. No.
And why not? Isn't the later settlement to some extent dependent on whatever groundwork was laid from day one, whatever depositions were taken, whatever motions were argued? Doesn't all that inure ultimately in whatever settlement they get from each defendant?
My understanding is that even if you've done work that led to that's not, once there's an actual conflict of interest, you're cut off. You can't get compensation.
Doesn't the Supreme Court say you get fees for what you did before this arose, but not after?
The way I'm reading that, he got the fee from before. In fact, he got more because he got the fee from the Gilbert Southern settlement after the actual conflict arose. So I think he, as I said earlier, I think he got more than he probably was entitled to. Shouldn't get greedy and be looking for more money from.
Well, is it your position that once the conflict arises, any fee that is paid after that date, any settlement that's paid after the date, he forfeits his fee? Or is it only any fee earned after that?
No, I think it's any settlement that's consummated, not paid.
Okay, if that's your position, let me give you this hypothetical and see if you would agree with that. There is no conflict throughout the entire development of the case. All the discovery's done, all the motions are filed. A settlement offer is made of $5 million. The plaintiff sits down with his two clients, and they now have a disagreement about how to divvy up the $5 million. And so he has a conflict and now has to get out of the case, and a week later the $5 million is paid by the defendant. Is your position that the plaintiff doesn't earn any fee because the entire $5 million came in after the conflict arose?
If he got out of the case before the settlement was consummated and did the right thing and did the ethical thing and withdrew from the case, and then a lawyer without a conflict consummated the settlement, then he should get a quantum error fee. But if he stayed on the case, notwithstanding the actual conflict that prohibits him from representing both parties, and then effectuated the settlement, that's a different situation. He should not be in the case.
It's sort of like a sanction at that point, what you're saying. Is because the attorney stays in the case, even if he'd earned a fee up until the time of the conflict, we're going to sanction him and take away all of his fee because he didn't get out when he should have. Is that your position?
Maybe a sanction to encourage lawyers to when there's a close question.
And what do you think is the best case, or any case you have that supports the proposition that if he doesn't get out, he forfeits his entire fee, including any fee earned before the conflict arose?
Let me consult my brief. In the case of Adams versus Montgomery, Searcy, and Denny, that on page 10 of our brief, 555, Southern 2nd, 957, an attorney's right to a fee terminates when the attorney realizes or should realize that he or she cannot ethically represent his or her client. And in my opinion, when the right terminates, that's the end of the story. There's no fee after it.
Okay, well, let me sort of trace that case back then, because the only authority in the Adams case for that proposition is the White case. And the White case says the same language, which is an attorney's right to a fee terminates when the attorney realizes he cannot ethically represent his client. But the only cite for that case is the Hill v. Douglas Supreme Court case. And the Hill case very clearly says you get your fee that you've earned up until when the conflict develops. So I see that language in both the 3rd District case and the 4th District case, but I don't see where any of the authority they cite supports that, since the Supreme Court case very clearly says that you get your fee up until the time that the conflict develops. You agree that that's what the Supreme Court case says?
Well, I think I agree, but I think that I'm not that familiar with the facts, and I can't agree that applies to the factual situation here. But I would suggest to the court that if the court is inclined to interpret it that there's some quantum merit for the last settlement here, for the work that was done before, then that should also open up the fee on the Gilbert Southern settlement, because I believe by that time there was the actual conflict, and he shouldn't have gotten the percentage contractual fee.
Well, but you haven't appealed that fee, right? You didn't file a cross appeal to say that that fee was improperly.
No, I didn't.
And in fact, you didn't even argue below it wasn't improperly paid, right?
No, dude, I'm just saying what makes sense if the court's going to open up, if the court's going to open it up like that. I don't think it would be fair and equitable to let him have all of one when he wasn't entitled to that fee and part of another one. I think that the thing to do is to affirm the court below that decision was made based upon a consideration of all the factors, including consideration of the factor that Mr. Butler had got paid the fee before.
What was your understanding as to the testimony below regarding the allocation of the first big fee? Was it the defendant who offered it already allocated, or was it offered as a lump sum and then allocated by claims counsel?
I was looking for that during Mr. Kupfer's argument after that question arose, and I couldn't see anything, and I don't recall myself anything in the record about whether the defendant or somebody else had come up with that. But I just have my quote from page 476 and 477 of Volume 4 of the record, that Mr. Farrell was, quote, pressured hard by Mr. Butler to accept the 50% apportionment. If he was pressured hard to accept the apportionment, that made me think that it was not a take it or leave it situation, that it was an apportionment that Mr. Butler, with the existence of the actual conflict, was putting on to the parties here in this case. Unless the court has any other questions, I'll yield my time back to Mr. Hill.
Let me ask you one question. Under Wiggins versus the State of Right, would you agree that even if Mr. Farrow had separate independent counsel, that Mr. Butler would still have gotten a fee based on his work in procuring the overall settlement?
If he had,
he would have gotten a fee from Mr. Farrow's recovery based on Mr. Butler's participation or work in procuring the overall settlement.
if Mr. Butler,
And that was the rule. That was the whole point, as I understood it, of Wiggins versus the State of Right, is how to compensate an attorney who secures an overall settlement when there are competing interests and when there is another attorney representing one of the parties who's recovering. And the Supreme Court said that each attorney should be compensated, even if they don't represent the person, because there is a conflict of interest based on their own work in procuring the result. Isn't that correct?
well, I understand that to be the case, but I also believe that where there is a serious of enough actual conflict in a case, and there is not a separate attorney brought in to
Does that even make sense?
where there's not a separate attorney, because sure, where there's a separate attorney brought into the case, that protects the parties. That protects the parties, and I think it makes more sense to give the attorney who had the conflict a fee there, because the opposing parties' interests are being protected by other counsel, and they're not in this case. The parties' interests were not being protected by another lawyer here to temper that, so I think the rule should be followed that the right to the fee was gone. If there are no other questions, I'd ask that the court affirm. Thank you.
May it please the Court, Mr. Wasson started out talking about the standard of review, so if I could just touch on that for 1 second. I started out saying, I believe in my previous argument, that we're taking the facts of this case just as Richard Farrow himself testified to, so that there's no question about the facts. We're taking, that's the hand that I've been dealt with in this appeal, and that's what we're working with. I think the issue now on appeal is a matter of law, looking at the facts as Richard Farrow himself said they occurred, is at what point, as a matter of law, does an actual conflict of interest arise for the attorney. I do believe that's purely a legal issue, and I think that it's subject to de novo review, and I respectfully disagree with Mr. Wasson about this.
Why wouldn't the conflict occur at a point where one client is pressuring another client to take a settlement that he's unsatisfied with by saying, I'm not going to participate in the lawsuit, I'm not going to testify? That would appear to be a conflict.
And I acknowledged before, I think at that point, arguably at that point, a conflict arose.
And that was at the time of the Gilbert Southern settlement.
Well, why didn't it arise with their Southern settlement?
Because that didn't happen during the settlement. That's where
Testified that he was unhappy with this settlement, and the only reason he took it was because he was promised that he'd get everything in the future.
He says that in order to agree.
You have to believe what he said.
Oh, I'm taking that.
So why wouldn't that create a conflict right there?
Just because when you have two clients and you have a settlement offer and the two clients are trying to decide how to work out the allocation, and one of them says, you know what, I'm not really happy with this, but if you promise me that you'll make this up to me in the future, we still have defendants left in this case, by giving me most of those settlements, I'll agree to this settlement. It's the clients themselves can agree, I think, without creating a conflict of interest, how to allocate a settlement. As I said before, it's when they can't agree how to allocate a settlement. Now, I do think, to answer Judge Lawson's question, later on, it was in the very last settlement that the so-called threat not to testify at trial.
So you're saying Mr. Watson was incorrect in that?
I think Mr. Watson is incorrect, and without, I won't read the pages to you because I've got 41 seconds. But the pages in the record that support that threat came at the time of the last settlement on the morning of trial is volume 4 of the record, 258 to 259, page 239, and volume 6 of the record, page 45 to 46. Once again, I'm using the court reporter's original pagination pages. Mr. Watson interprets some of the case law saying that the attorney's fee terminates at the time that a conflict of interest arises to mean that they get no fee from day one. None of those cases say that it terminates nunc pro tunc, back to the time that the lawyer was first retained in the case. It stops at that point if the lawyer doesn't get a waiver of the conflict, and you still get quantum merit up to that. So, incidentally, the pages of the record indicating that Gilbert Southern dictated how it wanted its own settlement to be allocated. There was a question about that. That's at volume 5 of the record, page 633, volume 3 of the record, page 21, and volume 1 of the record, page 59. For all these reasons, we respectfully ask that the order on appeal be reversed. Thank you.
Thank you both.
Thank you. It's a very interesting case. Happy journey home. Hope you don't get stuck in traffic.